The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. There are 3 cases submitted this morning. They are Terry Rivera versus Woodward Resource Center in the matter of Douglas Arthur Kroll. And the last case is Iowa Attorney Disciplinary Board versus Michael Cross. The last case is now submitted without argument, and we'll now hear the arguments in the Rivera case. Ms. Zwagerman.
Thank you, Your Honor. May it please the court, counsel. The issue before this court is whether instruction number 15, the jury instruction regarding the overriding business justification language, was a proper instruction. And the answer to that question, Your Honors, is simply no. And there are lots of different ways that you can get to that no answer, but I think the easiest way, the way that doesn't require this court to overrule anything, any past case law, anything like that, is just to clarify the overriding business justification language and to ensure that the determining factor standard, which is the standard for a public policy case and the standard at issue in this case, that determining factor standard, which was the marshalling instruction, instruction number 13, already encompasses the overriding business justification language. So in order to kind of get to where the overriding business justification language comes from, if we look at Iowa case law, the first time that appeared was in the Fitzgerald case. And it was in a footnote, and it was referencing some Ohio case law and to a Mr. Parrott, Professor Parrott. It appeared then afterwards in Lloyd versus Drake without any reasoning or explanation as to why the 4-prong test for summary judgment was now 4 prongs. Excuse me, it was 3 prongs before, and now this 4th prong was added. So if we go back and we look at where the language for the overriding business justification language comes from, it comes from Mr. Parrott, as I said earlier. But Mr. Parrott's intent with this language was to be used with the lower standard in the Ohio case law for public policy cases of a motivating factor. It didn't have anything to do with the Iowa standard of the higher standard of determining factor. So, and he also intended this overriding business justification to be an affirmative defense. He called it specifically a business necessity defense. And in his treatise at 7.08 at page 7-103, he talks about specifically how the burden of persuasion and production need to be switched to the defendant. And in this case, Your Honors, there was nothing like that. There was no burden shifting, there was no affirmative defense, there was none of that. So basically what happened in this case was that we have the determining factor standard. And in Terry Rivera's situation, she had made complaints of a coworker putting hot peppers or jalapenos, some sort of hot pepper, into the eyes of a residential individual at Woodward Resource Center. And when she reported this, the jury had to weigh then, okay, were her complaints the reason that tipped the scales? Because that's the standard in Iowa with determining factor. Jury instruction 3100.3 tells us the jury's going to get the itemized causation elements, and it's going to say, okay, what was the thing that tipped the scales? Was it her complaints of abuse, or was it what defendants are arguing, that it was her attendance?
Well, let me interrupt you. Supposing we agree completely with your analysis of the treatise and Iowa law and so forth and so on. But let's look at the instruction itself, instruction 15, the flawed instruction. It's a causation instruction. It starts out, if Woodward Resource Center would have made the decision to discharge, even if it had not reported, et cetera, et cetera. It's all causation. Then the offending sentence according to your position, is the reports were not the determinative factor if Woodward Resource Center had an overriding business reason. Now, in context, an argument could be made that there's no balancing going on here. I think an argument can be made that to the extent you say business justification overrides a public policy termination, that is an affirmative defense and the burden shifts and so forth and so on. But as I understand the state's brief, they're suggesting, well, that may all be true, but here the offending language is in a causation instruction. And so it doesn't invite the weighing of competing interests, which is an affirmative defense, but what it really invites is simply, it just simply kind of restates, you know, the requirement that there be but-for causation. Why don't you address that argument?
Sure. Well, there are two things wrong with that. The first thing is under the, I think, Crawford v. Yachty case and also Smith versus Smithway, restating the causation element is probably improper. When a causation standard is already properly delineated like it was in instruction number 13, now we have, you know, the potential for error. It becomes confusing. The jury has more than one sort of causation instruction. You also can look at that with instruction number 11, I think, because that was the instruction that says that Terry Rivera was an at-will employee. And when you're an at-will employee, you can be fired for any reason or no reason, so long as it isn't an illegal reason. And so the jury was already properly instructed on those causation elements. And what this particular instruction did, Your Honors, was that it took those scales that we're supposed to be weighing the evidence on, and it said, okay, now we know that she made complaints. That was not disputed. That was not disputed through the trial. But what it did was it said, we're going to remove those complaints from the scale. So Terry Rivera's complaints were removed from the scale entirely.
Well, I don't think it says that quite. I mean, frankly, I may not be very fond of the sentence, frankly, and I know you're not, but it may well be taking much of your argument for granted. It may well be it would have been better had the sentence not been there. But our cases generally suggest you don't have to have perfect instructions. You got to show prejudice of some kind, and that prejudice can certainly come from confusing a jury. And our case law says that I think the prejudice can come from overemphasizing an element. But yet, as I look at it, I mean, you're kind of retreating to the notion that the jury was invited to balance. And for the purposes of this discussion, I'm saying that's improper, that isn't affirmative defense. I'm kind of agreeing with that.
Okay.
But I'm coming back and saying, yeah, but can a jury figure out that this is in the context of causation? And if indeed she would have been fired in any event, but for causation has not been shown here, state wins.
Okay, well, I think there are a couple of ways to address that. I think one is that the way that you're phrasing that is if she would have been fired anyway, again, has to be in the affirmative defense. That is similar to what we have in discrimination cases, like the same decision argument.
No, it could be, because this is all contemporaneous. I understand all that after acquired evidence stuff and so forth, but the causation element has to be, I mean, it's a kind of a mixed motive, I suppose, but at the time of termination, when the decision maker was making the determination, if the state can show that termination was going to occur because of the absences, even if there had been no complaints and so forth and so on, they win, do they not?
Well, I think, yes, I mean, if that's what the jury is doing when they're weighing, okay, that's what we're asking the jury to weigh.
You can weigh causation. What you can't do is weigh the policies. And again, I'm kind of, for purpose of our discussion, agreeing. But surely they can weigh causation and determine that you failed to meet the burden, the but-for burden.
Absolutely, Your Honor, that is absolutely, but that's what instruction number 13 was for, because that laid out the elements, and those elements were consistent with the model jury instructions. The problem is then, after the jury weighed those elements, the court then instructed them to say, hey, now look at this, remove that she even made complaints, and would they have fired her anyway? And when you do that, you are having a burden shifting. There is a burden shifting. They remove complaints. That's actually a problem with commenting on the evidence, because the jury is asked to pretend something that didn't even happen, which I think is a problem. But then you get into the overriding business justification language, and that is not defined here. And if we go back to what overriding business justification...
Well, it doesn't say justification, it says overriding business reason.
Right. You're right, Your Honor, I misspoke there. But the overriding business, to override something means you have to set aside something. And in this case, the attendance policy did not override her mandatory reports of abuse. So in the situation where Mr. Parrott was talking about when something could override something else, he was actually talking about compelling public policy interests.
I mean, doesn't that kind of cut against you that there isn't a definition of overriding business reason? Because if you read the entirety of Instruction 15, what it's all about is determinative factor, which we all agree is a correct thing. That's what the jury should be deciding. And with no definition of overriding business reason, wouldn't we logically conclude that the jury would just assume that it's an illustration or an application of this determinative factor process, especially because if you go on in 15 to the part that we haven't gotten to yet, the judge said, well, if it's a pretext, then it's not a determinative factor. So if it's a business justification that isn't the real business justification, that's not going to work under this instruction.
I understand what you're saying, Your Honor. I think as far as the pretext analysis, that is just part of, one way that a plaintiff can prove the underlying claim for the determining factor. If there's if the reasons that they gave were false or something like that. So I don't think that there was anything wrong with the pretext instruction. However, with the overriding business language, that is sort of a term of art. That is a legal term. That's what this court has decided they're going to use on the fourth prong of summary judgment. And so to include that in here is confusing, because the way that overriding business is supposed to work is that it is something that is so compelling that it overrides. I mean, in situations where you have the overriding business, the employer is admitting that they are taking part of the protected activity for that public policy and using it as the reason that they are terminating the individual. In this case, Woodward has never done that. They have said from day one, it's attendance. It had nothing to do with her complaints. It's only attendance. And so when you're weighing those factors, like the jury is supposed to do in instruction number 13, they can weigh them, they decide. But in this case, then the court said, okay, you're not going to, I know that you've weighed those, but now I want you to really think about whether or not they would have fired her anyway. And I think that comes back to the affirmative defense. If we're going to have that sort of language, there needs to be a clear burden-shifting instruction.
The jury certainly didn't have that context and background when they were given this instruction, though.
You mean of the Parrott analysis?
Yeah, right, as you just described.
No, they did not have that background or instruction.
So wouldn't they just consider this to be a balancing of the reasons and find out what the real reason was?
I don't think so, and Your Honor, I don't think that's what they could have done, because this is telling them to assume facts that were already to assume facts that were not in evidence and were not undisputed, and to dispute them. And so it really left Terry with no choice. One of the things that I think is important is we had very good evidence in this case. We had very good evidence to suggest that this attendance policy that they fired her for was not really even a policy.
I mean, wasn't there some evidence that was kind of damaging to your client? Like one of the absences where she was supposed to be ill, she was at a garage sale and a fellow employee saw her there, and then she testified, well, I was only there 20 seconds and it just so happened that was when the fellow employee showed up. I mean, one could argue that a jury might be that's not the best evidence for your client in front of a jury, I don't think.
Well, I think, Your Honor, to respectfully dispute that, the garage sale evidence was not even on the scale. And the reason it wasn't on the scale for the jury to determine that, because the individual who made the recommendation for her termination, her direct supervisor, testified absolutely, at least on 2 occasions during the trial, that she did not take that into consideration. So the garage sale was not in her decision to terminate. And the person that she gave the recommendation to terminate, who knew about the garage sale, didn't make the termination. It was Mr. Mark Boley. So that was not even on the scale to terminate. It was evidence that the jury could have considered. Maybe they would have fired her anyway. But in this case, there was a lot more evidence to suggest that they did not follow this attendance policy. Certainly that they did not follow this attendance policy because it wasn't even one. The attendance policy that Ms. Rivera signed off on said she got 10 absences. That's in the handbook. That's what was explained to her. But they fired her after 3 absences.
Well, what do we make of the whole idea that this is a probationary employee? I mean, she doesn't have the standard protections that you might have under the union contract, which provides for those 10 days. We have not only an at-will employee, of course, but we also have a probationary employee as well. And certainly the rules can be different as far as absenteeism when it comes to that, can't they?
Well, I agree with you, except, then we get into sort of more of the balancing test and weighing of the evidence. And this 3 absence strike, 3 policy absence strikes and you're out was not something that they applied consistently. And we had put on sufficient evidence of that. In fact, Penny Van Sciver is probably the closest person we have to Terry Rivera, and she was employed after the fact. She also made a complaint of abuse, and she was fired on her next absence. She was in her probationary period, and by the time she had her complaint, she had 6 absences. And that's if you take the strict interpretation that John Andorf described. If you take Woodward's interpretation, she had at least 3 absences, which was still 1 more than Terry Rivera. But both women in this situation were fired after they made the complaint of abuse. And so I think, Your Honors, I see that my time has expired. Thank you.
Thank you as well, Counsel. Mr. Thompson.
Thank you, Chief Justice. May it please the court. As you know, this case has a long procedural history, and we're here today again because after a 5-day trial, plaintiffs, with some help from Judge Bennett and what I think is an outdated pattern jury instruction from the state bar, persuaded the trial court to omit one of the elements of the plaintiff's case.
What do you make of Parrott backing down?
Excuse me?
What do you make of the treatise writer backing down? It seems to me he has. I mean, he originally said it was part of an element, and clearly, I mean, we've read the cases, we did pick it up. But it seems to me that Parrott was probably wrong, and we may have been wrong. I understand what happened. We read the treatise and we put it in. Mm-hmm. But where indeed we have the standard of motivation, the standard in this case, overriding business justification is an affirmative defense. I mean, that makes complete sense to me. I have other problems with this case, as you've probably picked up, maybe. So tell me why we should follow the Parrott treatise when he's abandoned it himself.
Well, I mean, let me begin by saying in Fitzgerald, I don't think this court adopted everything that Professor Parrott said or everything that he said in his multiple treatises or multiple articles, which I think we've all struggled through. All this court did in Fitzgerald, and this is real important, is to, in addressing the development of the case law, dropped into a footnote a discussion about a way to view 4 elements, a structure. But in that footnote, what Justice Cady said was, and this is important, that this is a framework that's consistent with the way that we have been evaluating these cases on a case-by-case basis since inception. and specifically refers back to the teach-out case and some other cases. And the teach-out case is a good teaching case because it goes through a series of cases, Graves, Phipps, Holm, in which in every case, and generally deciding a case as a matter of law, this court talked about other reasons that were in the record for termination. And
Well, but if it's a balancing of policies, I mean, it's one thing to say causation. I mean, I for one, in this case, have separated those issues. There's a causation issue and maybe a balancing of policy issues. To the extent there's balancing of policy, that's an affirmative defense almost for sure, it seems to me.
I agree.
And I invite you to, of course, to challenge whatever I say. But it seems to me, if it's balancing, that's an affirmative defense. On the other hand, if it's directed to causation, that's a different matter. The plaintiff plainly has, at least as initially, the burden of causation. And then the question only arises whether the instruction is confusing or unduly emphasizing, kind of an element of the case.
Well, I think these cases show, and Fitzgerald illustrates, that this is about causation. It's not the causation element. We have a line of cases, teach out, and really starting with Smith, that talks about the determinative factor as the definition of the causal requirement that is one of the elements in the case.
Yeah, but the instruction then says overriding business reason. I mean, frankly, listen,
Right.
Instructions are rarely perfect, and I get that, but I guess one of my jobs is to pick apart instructions. But, overriding business reason certainly wasn't the best selection of terms. Overriding kind of suggests that the jury's invited to balance the importance of policies, which was not in their purview. It is true that the sentence appears in a causation instruction, and one might suggest context, they'd figure it out.
Right.
And that's plausible. On the other hand, the jury's going to read that and think it has independent meaning from the other sentences in the instruction. I mean, couldn't a jury be kind of confused and think, well, we think this attendance policy is really important and it trumps the alleged reporting?
Well, no, I don't think so. But I think it's important to go back because you said if causation, it's easy. The plaintiffs have the burden. This court has said the plaintiffs also have the burden to prove something else, which is the absence of this justification. And Justice Bennett and Judge Bennett and others have said, well, that's a problem. You got to prove a negative and various issues. But this court in Fitzgerald, in cases that led up to Fitzgerald, talked about these other justifications in the context of causation. Every single one of them, Graves, Phelps, all of them talk about how that affected their view of the causal evidence and what was sufficient as a matter of law. And so now what we have in the context of this case is a trial court decision to pull that out as an element, and so that the plaintiff doesn't have to prove it based on an argument made by plaintiff and by Judge Bennett that the reason we should pull it out is that it is implicit in the causation standard, and all the court did was make it explicit.
Well, could a jury, I guess I'm confused, but could a jury, a but-for standard I think is clear. I mean, everybody agrees that it's a but-for standard. The plaintiff must prove it.
Yes.
What does the sentence add? You got to show but-for. Plaintiff's burden. Why even have the sentence?
Well, the reason the sentence is there, Your Honor, is because it's an element of the plaintiff's claim under this court's 10-year line of cases. And then what the trial court did, because plaintiffs compelled him to do it, is ignore that and said, okay, if it's implicit, I'm going to go ahead and add it to the determining factor instruction, because you've agreed that it's implicit in that very standard, and simply say, just like the same decision argument, in other words, I think plaintiff conceded, in fact, in their brief, that in answer to your question, that if the jury believed the reason for the termination was attendance, another business reason, that just means that it was the determining factor. And so if I understand your question is, well, if it's implicit, and this is kind of the Judge Bennett argument, if it's implicit, then why restate it? Is that somehow an improper comment on the weight? And I think under these circumstances, in this case, it's not, in part because of the fact that it is, in fact, an element of the plaintiff's burden. And so what the instruction is not confusing, Your Honor.
I
And
think it's a separate element. I'm having trouble. I mean, I think there's a causation element. There's only one element. I understand your argument about explicit and implicit. I'm going to recharacterize your argument a little bit, but I think kind of what you're saying as well. It merely repeated. It's consistent with the prior causation language, and it merely, basically repeated what was implied in the earlier instruction. But it does so arguably in a confusing way. I mean, overriding, trumps is a term you see in the cases, trumps this, trumps that. When you see overriding, could a jury kind of think that it trumps the causation element? I mean, I understand it's part of the causation instruction, which I think is something that cuts, kind of in your direction.
right. Well, I think the answer is this. I mean, I don't think so, in part because you have to read these in context. So you look at 13, you look at 15, and you look at all of 15, not just part of 15. And so you have a series of things that informs the jury that because the standard under teach out in Smith is determining factor, but that means more than that, because this court has said, well, that means it has to be the thing that tips the scale, right? So now the instruction helps the jury understand what that means by first saying, if they would have done it anyway, it didn't tip the scale. And if there is another compelling interest, then it doesn't tip the scale, because that is something that is proffered that they should weigh, which is exactly what Judge Bennett did when he ultimately charged the jury. But the saving, the saving grace here, Your Honor, is the pretext instruction. And the pretext instruction gives the jury the absolute explicit instruction that if you don't believe any of the above, any of the reasons proffered by the defendants for the discharge, then you may still find that the discharge, or that the report in this case, was the determining factor under the causal standard.
Well, but what if the jury believed that there was an attendance policy, and maybe the jury struggled with this case? I mean, frankly, there's evidence on both sides. Obviously, you fought it out in 5 days, and jury might have said, well, attendance is important, and we credit at least some of the testimony of the state's witnesses that there have been probationary employees, and sometimes they're fired for attendance problems, and that, that is serious. But there's also evidence the other way on the reporting, and I know you contested that evidence, but the point is, another member of the jury could say, yeah, this attendance thing is out there, but boy, oh boy, this looks sorry to me. You can just imagine that in the jury box. And then so they're having this debate, and then they look at the instruction, and can someone say, well, I don't know about causation, but attendance is important, and it's an overriding business reason. Verdict for the defense. Now, that would have been an improper argument. I think you'd agree.
Well, I don't think we made it. Number one, but I don't. I guess hypothetically it is, but I don't think I think if you read these jury's instructions as a whole, that's not what is compelled. And again, it's kind of instructive, maybe ironic, to look to Judge Bennett's final decision in his case, where after not getting a certified answer to his question, he kind of repeats his concerns, but then he points out, number one, I expressly instructed the jury to consider other justifications. I expressly included a pretext instruction, and therefore, in a case where the defendants lost and didn't get their instruction in terms of the element, that there was no harm, essentially, because the jury everybody was able to make their arguments, and the jury was able to weigh all this stuff. But I want to get back to the why question. Why is it improper to somehow have a separate instruction? Number one, if it's implicit, how can it be prejudicial? Number two, it's absolutely consistent with this process. And there is no, let's just be clear, there's no affirmative test, affirmative defense here. This court has not created one. There's no burden shift. And so what's happened here, at a minimum, is the burden of production has shifted to the defendants on something that was an element of the plaintiff's case. But in Jasper, this case, this court, in one of the most recent applications of all four factors, because one of the things that plaintiff has argued is that this is a summary judgment standard, and we've got Jasper and we've got the Dorshkin case, both of which were jury verdicts, both of which applied determining factor and the justification component set out by this court. So it's not just a summary judgment issue. But in Jasper, Justice Cady specifically said in discussing why we apply both the framework, the causation, and the justification, it is not the intent. The tort is not intended to interfere with legitimate business decisions of the employer. I mean, that's a statement of the court about it reflects the narrowness of the tort. It reflects the public policy of the tort itself. One of the things that's been, in the briefing at least, that has started to get confused is this isn't about the first two prongs. I mean, Justice Wiggins in Dorshkin went through and did a detailed analysis of the first two prongs of where we have to balance the policies to decide if the tort fits. That's not this case. 1 and 2 aren't in play. This is about have you proved that this protected activity was the cause, the but-for cause of your termination. And what these elements do and what this instruction does, consistent with the elements this court has applied for years, is to focus on the fact that this kind of evidence is something that's important and ought to be looked at. But it doesn't amount to a directed verdict.
Let me try and, is the state's, or at least one of the state's positions this, which is Judge Bennett said in Hagan that we should not consider the lack of an overriding business reason as a separate element, but it ought to be wrapped into the determining factor analysis. And that's what Instruction 15 does. Is that one of the state's positions? So you can agree entirely with Judge Bennett and you can still uphold the jury verdict here. Is that one of the state's arguments?
I think that's, yes, I think that's one. In other words, that this is consistent with what Judge Bennett ultimately did and ultimately concluded was not prejudicial to the defendant who lost the case.
So in other words, you're saying a jury could not have decided that causation was because of the retaliation, but the attendance policy trumps that.
I don't think so. Yeah. But it's important to note, again, I think the context is important here, that we're talking about this instruction as if 10 years of your cases written by a number of the folks sitting on this bench that recite the elements of a common law cause of action, and that one of the things that puts us here is that the trial court refused to submit one of the elements of the cause of action that this court has applied as recently as last year in 2 different cases. And so it's within that context you have to analyze whether referencing overriding business justifications is somehow a material misstatement of the law, if it ends up with the same basic result or puts plaintiff in no worse situation than what the law required in the first place. If anything, it arguably shifted the burden on an element of the plaintiff's claim to the defendant. And it's very difficult to understand how that prejudiced the plaintiff in this case, which is really the standard we're kind of bootstrapped, and my time's running out, but we're bootstrapped because I don't want to argue that this is a correct statement of the law because we think it was wrong. We said that sentence should be in the marshalling instruction. Judge overruled that and says, well, I'm going to put it over here. That's why it's there, and that's very important to this. But in the end, it didn't prejudice the plaintiff. It was not confusing. It shifted the burden to the defendant on that's something the plaintiff should have proved, and you should affirm the jury verdict.
Chief, could I follow up very quickly? So do I understand correctly that we can affirm this case without reaching the question of whether the overriding business reason is an affirmative defense?
Absolutely.
And yet, if we did go further and decide that, in this case, that it is an affirmative defense, to do that, wouldn't we have to overrule a line of our prior decisions that have the 4 elements?
Yes, absolutely.
Thank you, counsel.
Thank you, Rob.
Zwagerman, rebuttal, please.
Thank you, Your Honor. When I was preparing for my argument, I actually thought about asking you all to kill that 4th prong, just to kill it, because we have that higher determining factor standard. And if you look at the cases that actually apply the overriding business justification language, when I put that search into Westlaw, I got a hit of 49 cases. And of those 49 cases, there were 3 states. It was Iowa, Ohio, and West Virginia. And Ohio and West Virginia, who both use that language, both have the lower standard of motivating factor. And since we bring it back to Parrott and what his intent was with this, it really makes sense that we would use it as a motivating factor affirmative defense like he is suggesting. I think what's also important is that jury instruction number 15, we've talked about this, and Woodward's argument, as I understand it, is basically that they weren't asking, what they're still suggesting is what was being done during that initial determining factor weighing process. And what this instruction did when it said, if Woodward Resource Center would have made the decision to discharge Rivera, even if she had not reported the suspected abuse, if we're applying this in the context of not an affirmative defense, we have to go back to the marshalling instruction, and we have to have those scales, and we have to say, okay, remember, determining factor is a mixed motive. We can have complaints, we can have attendance on the employer's side, we can have...
Ms. Zwagerman, let me go back to the language you just quoted. I mean, in order for there to have been some kind of injustice in the case, the jury would have basically had to have ignored that language, because it was very clear if Woodward made the decision, it would have made the decision to discharge, even if she had not reported suspected abuse, the reports were not the affirmatively determining factor. So that's correct. That's a correct statement of the law, and that defines determining factor, right?
No, the determining factor is the thing that tips the scales. What this is doing here, Your Honor, is it's removing the mixed motive process entirely. When you have the determining factor, you can have attendance, you can have insubordination, you can pile those things on. And what this did was it said, okay, you've got your scales, and it said remove that she made the complaints. All you're left with...
I just don't read it that way. It says if they would have made the same decision anyway, the reports were not the determining factor, and your client loses. Isn't that a correct statement of the law?
I still disagree with that, because we're using the same decision anyway, which again I think is the trigger for the affirmative defense. But this says even if she had not reported suspected abuse. And that is my problem, is because we're removing her reports from the scale entirely. Even if she had not. That's a comment on the evidence. It's a comment on evidence that was not supported. And I think under the prior case law of this court that's improper.
Isn't that just a paraphrase of the but-for standard? I mean, if she would not have been terminated but for making the reports, then the reports were the determining factor. If she would have been terminated anyway, then they weren't. I mean, aren't those just two sides of the same coin?
I don't think so, because it suggests something different than what the standard that this court has upheld for what the determining factor means, which is the things that tips the scale decisively. And you can have 7 things on one side and 1 thing on the other side, and that one just weighs more. And
Well, the instruction did not tell the jury to remove the reporting of abuse from consideration.
I sort of disagree with you on that, Your Honor, because it says even if she had not reported suspected dependent adult abuse. It didn't say, hey, jury, don't consider it at all, but it said, pretend for a second that she did consider it. And I think that is the problem because, well, yeah, she may still have been fired for that, but that may not have been the thing that put it over the edge. And when you don't have the thing that's putting it over the edge, that's tipping the scales in the factors, then the jury isn't properly weighing the evidence that was before them. So for these reasons, Your Honor, we ask respectfully that you...
let me just
Okay.
ask you a quick question. In a case of this nature, when we get down to this element, it all comes down to what's the reason why the person was fired. And the employer offers up some reasons, and the employee offers up reasons. The employee's reasons are protected. The employee's reasons are protected. Employers are the business justifications. And so isn't it fair to ask the jury to assume, well, would this thing have happened if this event would not have occurred? Isn't that a perspective that the jury can go through in trying to decide what was the determinative factor?
Well, if you're going to have a question that way, Your Honor, then I think you have to do the same thing. Is it if her attendance really hadn't mattered? You know what I mean? So I think we start getting into lots of comments on the evidence, which then we're going to have endless jury instructions. So for those reasons, Your Honor, we would ask that you remand the case for a new trial.
Thank you. The case is submitted. We'll now hear the arguments in the disciplinary matter.